This is the hearing at which we will hand down our judgment on this referred appeal. We first want to hear counsel, if they wish to address us, about the consequences of the decision which we've reached, which we have shared with them in the form of a draft some little time ago. The decision we've reached is that this appeal will be allowed. The conviction for murder will be quashed. We will direct a retrial. I think counsel may wish to make some submissions about our intention, which is that we will also certify a point of law of general public importance and, in this unusual case, give leave to the prosecution to appeal to the Supreme Court, at which hearing the law can be considered in a less constrained way than we are required to deal with it. Mr. Perry, do you wish to address this?
My Lord, no. We've made our submissions in writing, my Lord.
Thank you very much. Mr. Jeremy.
Thank you, my Lord. I do, and I will make them shortly. In this case, the court has not followed the usual sequence of first issuing its judgment and then considering any consequential application for leave to appeal. It has instead stated that it would certify that its decision involved a point of law of general public importance which ought to be considered by the Supreme Court, and that it itself would grant leave to appeal. It follows that the decision to certify a question has been taken before the question has been identified, that leave to appeal has been granted without it having been applied for, and that the appellant has not had the opportunity to respond to any such application. This appeal is therefore not brought at the instance of the defendant or the prosecutor, as provided for in Section 33(1) of the Criminal Appeal Act, 68, but at the instance of the court. The decisions to certify that a point of law of general public importance is involved in the decision and to grant leave to appeal having been made by the court, the appellant does not seek to go behind them. But the submission that would have been made on his behalf, had there been an opportunity to make it, and that now be made to the Supreme Court, is set out below.
I think you're referring to a document which we have read, and therefore to a submission which actually has been made.
I am.
Yes. So when you said you would have made it, you have actually made it.
Yes.
Thank you. And we've read it.
The submissions are as follows. For the following reasons, the decision of this court to allow this appeal did not involve a point of law, far less one of general public importance, which ought to be considered by the Supreme Court. It is also submitted that there is no sufficient reason to depart from the usual practice of deferring to the Supreme Court as to whether leave to appeal should be granted. The law, as determined by the Supreme Court in Kennedy No. 2, is clear. It was accepted to be binding by the parties and was accepted as being so by this court in CACD Judgment 1. But while CACD Judgment 1 purported to apply the law as determined in Kennedy No. 2, it did not do so. It circumvented the law by the creating of a flawed analogy between the facts of this case and those of the hypothetical weak swimmer. CACD Judgment 1 did not decide any point of law. The court amended its draft judgment in order to avoid doing so. The draft judgment of this court therefore erred in stating at paragraph 36(1) that CACD Judgment 1 had found that and I quote, that the undisclosed intention of the person with whom Mr Farquhar drank the whisky would, in law, render his decision to drink it involuntary. For the reasons submitted by the appellant at the hearing of the appeal on the 5th of March of 2026, neither judge nor the court in CACD Judgment 1 made this finding. The trial judge, as the transcript of the exchanges at the time of the jury questions shows, thought that causation was a question for the jury, although he doubted that it could be an issue. And the court in CACD Judgment 1, while it appeared to make the finding at paragraph 63 of its draft judgment that Mr Farquhar's act of drinking could not have been free, voluntary and informed, subsequently amended that paragraph to remove that phrase following receipt of the appellant's application for a rehearing, which pointed out that this would have been a finding of law. In its draft judgment, this court has applied the law as determined by Kennedy No. 2. In doing so, this court determined at paragraph 43 that the court in CACD Judgment 1 was bound by Kennedy No. 2 to quash the conviction. A decision that the court in CAC Judgment 1 should have applied the agreed law to the facts of a case rather than circumvent it does not involve a point of law, far less one of public importance that ought to be considered by the Supreme Court. This court's reason for certifying is given at paragraphs 42 and 43 of its draft judgment, when in answering its own question, did CACD Judgment 1 impermissibly depart from Kennedy No. 2, and having disagreed with CACD Judgment 1, the court's judgment said this: a better course in our judgment would have been to allow the appeal and grant such a certificate so that the prosecution could have sought a ruling from the Supreme Court on the scope of Kennedy No. 2. Since we take the view that this is what that court should have done, this is what we will now do. It does not follow from this court's finding that the court in CACD Judgment 1 was wrong to refuse to certify that a point of law was involved in its decision, that a certifiable point of law must be involved in the different decision of this court. There is no equivalence between the two situations. The question of whether to certify that a point of law of general public importance is involved in the decision to allow the appeal falls to be considered afresh in the light of the reasons for the decision and the submissions of the parties made in support of and against any application to certify. As to the granting of leave, the reason why this court took the unusual step of granting leave to appeal is given at paragraph 62 of the draft judgment. While the question of whether cases such as Wallace and Rebello have correctly applied the law as determined by Kennedy No. 2 is undoubtedly an interesting and important one, this case does not turn on whether the principle in Kennedy No. 2 requires reconsideration. This case does not turn on what the law is or what the law should be. It turns on the willingness of the court hearing the appeal to apply the law to the facts of the case. Furthermore, the extent of the misdirection of the jury in this case, both as found by this court and the further misdirection in relation to minimal cause, which was advanced as ground of appeal 4, has not been considered in the draft judgment and was such that no revisiting of Kennedy would be capable of rendering this conviction safe. Although the consideration of urgency, which has been added to paragraph 62 by the second draft judgment that was circulated on the 31st of March 2026, would, in some cases, be a valid consideration, this defendant is a serving prisoner and will remain one for some years, whatever the outcome of this appeal.
Could I just ask you about that, Mr. Jeremy? Why is that?
Because, my Lord, of the sentences passed on the other convictions.
7.5 years.
I'm so sorry?
7.5 years.
No, my Lord, 16 in total.
16 in total. Where do we see that?
In the sentencing remarks, my Lord.
Yes, they're not on. I went back to the warrant, the order of the court. But
my Lord, it's not.
we haven't been invited to consider sentence, obviously, so we
So
don't have the materials available to us. So that's why I'm asking for your help.
I understand. without criticising anyone, they're not easy to read, but my reading of the combination of consecutive and concurrent sentences produces a total of 16, and I take that from the sentencing remarks.
Yes. Mr. Perry, do you know what the answer to this is?
My lord, we calculated it at 7.
Yes.
So I'm afraid I was labouring under a rather different view, but obviously we'll have to check it because it's going to have an impact on the expedition of the appeal.
Yes, it will do indeed. And it certainly does impact upon the question of urgency, although there are other public interest factors in these issues being resolved without avoidable delay, apart from your client's personal position. It nevertheless is an important factor and one we should get right. So are you able to tell us that the concurrent sentence which he's serving currently until we quash it alongside the life sentence is a term of 16 years?
Well, not categorically, my lord. All I can tell you, as I've said, is that that is my best effort at interpreting the sentencing remarks by adding together the combination of concurrent and consecutive sentences. I have, as you'd expect, made that inquiry of my instructing solicitors to try to find a release date for the other offences. No answer has been forthcoming. It may be that that is an impossible question to answer because, of course, while the life sentence is extant, an alternative release date will not have been calculated. So I can tell you that my best endeavour has been to interpret those remarks. I don't have them with me, I'm afraid, but I calculate them as 16, and my inquiry to obtain confirmation hasn't borne fruit.
But in any event, that sentence was imposed, I think, in October 2019?
It was, my lord, and of course there was the time served to...
Exactly. So if he does half of 16, he's not far off.
But he'd do 2/3, my lord, because...
What was the sentence imposed for?
What was
the 16-year term?
Well, my lord, even on the sentence of 7, and I can't remember, I'm afraid, and I don't have the papers with me, even on the sentence of 7, he'd serve 2/3 rather than 1/2.
For any sentence, yes, exceeding 7 years.
Yes.
Yes.
It's six or more, my lord.
And we are, I think, are all in agreement that there was a sentence of at least 7 years.
There was.
So that would be at the 2/3 point. Yes. Thank you.
My lord, in conclusion, firstly, for these reasons, no point of law was involved in this decision, far less one of general public importance that ought to be considered by the Supreme Court. Secondly, there is no sufficient justification for this Court's decision to certify and grant leave itself, rather than follow the usual practice of allowing the Supreme Court to decide which cases it will hear. And thirdly, while there are now 2 conflicting decisions of the Court of Appeal Criminal Division, the conflict is not as to any point of law. The conflict lies between the willingness of the Court in CACD Judgment 1 to evade application of the law in order to uphold the conviction, and the unwillingness of this Court to do the same. That is not a conflict that requires resolution by the Supreme Court. The Court of Appeal Criminal Division, over a period of 5 years, has had 4, including the application for a rehearing, opportunities to confront and to correct the obvious legal errors made in directing the jury. An appeal to the Supreme Court will involve a further delay and therefore further uncertainty for the many who have been affected by this case and the failure to achieve a just finality. While this Court, at paragraph 25 of its judgment, has indicated that it has not been helped by a detailed examination of the history of this case, such an examination would be of help to those who wish to understand why they have been allowed to believe over 5 years that this conviction was safe. It is therefore the respectful submission of the appellant that this court should allow this appeal and refuse any further appeal. My Lord, on the other topics, the subject of the consequential orders, as you know, there's no application for bail. There are no submissions made on behalf of the appellant on the question of retrial. On the question of representation, and forgive me if this is an administrative application.
No, it's an application which you made in your written submissions, which, as I said, we did read and which we've decided to grant.
I'm very grateful. Unless I can...
No, thank you very much. Thank you. What we will do is to make it clear to everybody who is concerned with this case, who is following the hearing, what the outcome is going to be. We will then rise and consider whether, in the light of what Mr. Jeremy has said, we need to make any adjustments to the draft which currently exists, which is in a slightly different form from the one to which he has been referring, but which we will hand down shortly this morning. And while we are doing that, we will ask for some assistance from the Criminal Appeal Office in order to establish exactly what the sentence was that was imposed by the judge at the trial, so that we are in a position of certainty in deciding how we should express the need for urgency. As we have said, the appeal will be allowed and the conviction will be quashed. We will direct a retrial. In the meantime, before that retrial can take place, the matter will be considered by the Supreme Court. Because the Supreme Court, we will certify a point of law of general public importance for the Supreme Court, and we will give leave. And our objective in taking that unusual course is precisely to reduce the delay about which Mr. Jeremy has just complained, to the extent that we can. So we'll rise now and we'll consider the matter further.